Hi, and thank you for taking the time to watch this. My name is Sam Butler, and I'm a solicitor at Horsfield Menzies, a specialist law firm. Over the coming days, you will have a one-to-one meeting with me or one of my colleagues to go through your settlement agreement in detail. Before that meeting, we wanted to take a few minutes to introduce ourselves, explain what a settlement agreement actually is, and give you a sense of what to expect. We appreciate that receiving one of these documents can feel daunting, particularly at what is already an unsettling time. Our hope is that with this video, together with the written FAQs we've sent you, will help you feel a little more prepared and a little less uncertain before we speak. So, who are we and why are we involved? Because of the inherent imbalance of power between an employee and an employer, a settlement agreement is only legally valid if the employee who signs it has first received independent legal advice from a qualified solicitor. That's us. You've instructed us to act as your independent advisor, and I want to emphasize that word, independent. We're here for you and not for your employer. Our job is to make sure you understand what you're being asked to sign and to check that the agreement is fair and lawful. Your employer has agreed to meet our fees, so this advice will come at no cost to you personally. And everything that you tell us in our meeting or over emails is absolutely confidential. What you share with us stays with us. It will not be fed back to your employer. Let me explain what a settlement agreement actually is. Put simply, it's a legally binding contract between you and your employer. In exchange for receiving a financial payment, sometimes other benefits, you agree not to bring legal claims against your employer, claims such as unfair dismissal or discrimination. Once everyone has signed, that is final and binding. You may have heard these referred to as compromise agreements. That's simply an old name. The law changed in 2013, but the substance is the same. One thing I do want to be clear about is that you are not obliged to sign a settlement agreement. It is entirely voluntary. And we understand in this circumstance, if you choose not to, the redundancy process will proceed through the standard route. However, it's worth knowing that in most cases, the financial package offered under a settlement agreement will be more than you would receive through the standard redundancy process alone. Now, what can you expect to see in the document itself? On the financial side, your package will typically include your statutory redundancy pay, which is calculated based on your age, your length of service, and your weekly pay, along with notice pay, any accrued but untaken holiday, and what's known as an ex gratia payment. That last element, the ex gratia payment, is an additional lump sum paid in recognition of the agreement you're entering into. Importantly, ex gratia payments up to £30,000 can often be made free of income tax and other employee taxes, depending on their nature. We'll walk through the tax positions specific to your agreement in our meeting. Beyond the money, the agreement will also deal with things like your termination date, the terms of any reference your employer provides, confidentiality provisions, what you can and can't say about your departure, and the return of company property. One thing that often concerns people is the waiver of claims. Now, this is the part of the settlement that you confirm you won't be bringing legal claims against your employer. It will look long and it might seem quite alarming. What I'd say is employers typically want a broad waiver to give them certainty that the matter is fully resolved. In practice, most of the listed claims would never arise anyway. But it's exactly the kind of clause we'll go through carefully with you so that you understand precisely what you're agreeing to. On the question of negotiation, we've already engaged with your employer to satisfy ourselves that the agreement is compliant with the legal requirements and that the terms are fair and proportionate in these circumstances. We also understand from your employer that the financial figures are set for this exercise. So here our role is not to renegotiate your individual deal, it's to make sure you understand what you're signing, to answer your questions, and to ensure everything is legally in order before you decide whether to sign. So, what happens next? Well, if you haven't already, you'll receive the settlement agreement directly from your employer before our meeting. When you come to speak with us, it would be really helpful if you could bring that document and a note of any questions or concerns you'd like to raise. And please do bring your concerns. If you have any worries, our meeting is the right time and place to raise them. And again, I want to reiterate, the meeting is completely private and confidential. We'll know sooner to the time about the deadline for signing and termination dates, but if you feel you need more time, please let us know, because that's something that we can look at. We know redundancy is never easy. Even where the process has been handled fairly and the financial terms are good, it's still the end of something. And it's completely understandable if you're feeling anxious or uncertain about what comes next. Our job is to make this process clear and as straightforward as possible. We want you to leave your meeting feeling confident that you understand what you've signed and that you've had a genuine opportunity to ask the questions you want to ask. If anything occurs before we meet, please don't hesitate to get in touch, and our contact details are in the FAQ document. And we look forward to speaking with you soon.